Good day, everyone. Welcome to another YMCA YES talk here at the North Suburban YMCA. Today we have a great speaker. Matt Margolis is going to be talking to us. Matt is our favorite lawyer, talking to us about understanding Medicaid and how to protect assets legally. We are going to learn about the state's rules as it applies to Medicaid, and how much income and assets one or a couple can have when they're applying. If you have any questions, please save it for the end of our talk or put it into the chat box. Matt will address these questions at the end of our talk. We are an hour long and it is recorded so that we can find it later on our YMCA website. I am super excited for Matt. He's been talking to us for, gosh, over 5 years at this point, but so glad that you get to welcome us into 2024. So with that, welcome, Matt.
Awesome. Thanks, Pam. Good morning, everybody. I am going to start off by putting my contact information in the chat. I feel like I normally do that at the end, and sometimes I think I forget in general, so that way you have it in case you want it. Not that I presume anybody wants it, but just is out there for you. Thanks to Pam and the YMCA for continuing to allow me to speak to this community. You know, I love doing this. I think information is great, whether you need to act on it or not. You know, always good to have an idea as to what's going on regarding something that may or may not be applicable to you now, but you know, might come up down the road. So very quickly about me. My partner Lauren Weldon and I have a sort of what I'll call a boutique elder law and estate planning practice in downtown Park Ridge, and we not only do estate planning, meaning wills and trusts for the masses. You know, we do powers of attorney for 18-year-olds going off to college, all the way up to, you know, wills and trusts for individuals, you know, young families, up to individuals that are in their 90s or hundreds. You know, really just here to help whoever needs it in that regard. The other half of my practice, which my partner these days is handling the majority of, is more the elder law side, and that's where we assist folks that are sort of, you know, in that chapter of life where maybe they're dealing with a chronic illness, you know, maybe whether it's cognitive or physical, and you know, they now need some help. And you know, in some cases we're working with folks that need some help, but they're living in their own home, and in a lot of cases we're working with families and folks where, you know, a loved one has graduated, if you will, to living outside of the home in some sort of long-term care facility, whether it's an independent living facility, skilled nursing, supportive living, assisted living, memory care. You know, if any of you have kind of gone down this path with a loved one, you know that it's overwhelming. There are so many different types of places out there, you know, so you know, we're here to support people that kind of, you know, end up in that chapter, helping them, you know, discuss the ideas of protecting assets, applying for Medicaid, and in some cases it's just making sure that they've got all their ducks in a row. You know, as somebody's getting maybe diagnosed with dementia, and you know, at some point we know that they may not be able to make their own decisions, and how important it is to make sure that all their documents are in place prior to them losing capacity. So today's focus is talking about Medicaid and protecting assets legally, of course, right? I mean, we don't do anything that's not legal. In a lot of cases, even when some plans start to say things that don't sound so good, you know, that doesn't tend to be a good fit for us if we think that they're looking to do something that we don't agree with. So I'm going to do my best to cover as much material today as I can. Like Pam said, I'm happy to answer questions. If you are familiar with and, you know, able to use the chat function, feel free to drop your questions in there, whether you want to, you know, shoot them out to the group, or you should have the ability to just message me privately. If you don't want your name to be associated with the question, you can do that, and I can, you know, respond. Because yeah, I can either kind of take questions via chat, or we can wait till the end. It's hard for me to take any questions during the talk. And so that would be the best thing to do. I think Pam already talked about everybody muting themselves. It looks like for the most part, everybody is. If you are not muted, if you can, that would be appreciated, just to avoid any background noise. And last thing is any questions that I'm happy to answer any questions again that you put in the chat box or you want to ask at the end. I just really prefer that they're more general to the group and to the topics I discussed. You know, if it's a very specific question regarding you or a loved one or something like that, I'm happy to discuss it. But I'd prefer you maybe reach out to me privately. You know, like I said, I provided my information in the chat box, so you can always shoot me an email or give me a call, and we can kind of figure out the best way to handle that question depending on what it is. All right. So when we look at you know, the idea of Medicaid and protecting assets, I really like to start with you know, talking a little bit about Medicare. And believe me, we are not Medicare specialists by any means. I don't pretend, and neither does my partner, pretend to have any significant knowledge as it relates to Medicare. But the one thing I think people really need to be conscious of is sort of Medicare's limitations when it comes to covering anything long-term care related. All right. So, you know, Medicare is health insurance, right? And it's health insurance that for the most part we will get when we turn 65. Some individuals who are determined to be disabled by the Social Security Administration can get Medicare at an earlier age based on a disability. But again, for the most part, most of us are going to get Medicare when we turn 65. And again, Medicare is insurance, right? Medicare is going to cover, you know, various forms of Medicare. Will cover, you know, doctor's appointments, hospital stays, surgeries, etc. Medicare is not a benefit that is set up to cover long-term care. Okay. And I mention this because this is something that a lot of people that we've met with over the years, you know, they're confused by this. They think that Medicare will cover some long-term care, or maybe they don't know for sure, but they just have this assumption that it does. And so in general, I want everybody to know or to understand that Medicare really is not a long-term care benefit. Medicare has a very limited benefit when it comes to paying for something that we would sort of can be akin and make it akin to long-term care. So if I'm in a hospital and I have 3 overnights, okay, I'm 3 overnights in the hospital, and I'm considered to be inpatient status. All right, I can't be under observation. It's 3 nights in a hospital, inpatient status. Now I could be in the hospital for 8 nights, but at least 3 of them have to be inpatient status. I know I just said that 4 times. It's important because if I have at least 3 nights in a hospital inpatient status, and then I am discharged to a, in a lot of cases, if I need some sort of rehab, I'm being discharged to a skilled nursing facility that provides rehab. Okay. And if that's the case, and I've got those 3 nights of inpatient status at the hospital, and then I go to rehab, Medicare will cover the first 20 days of my rehab 100%. Okay. And then for up to, okay, I'm not guaranteed, but for up to another 80 days after the first 20, Medicare will cover my rehab at 80%. All right. And then the other 20% is going to either be covered or not covered, depending on what I might have in addition to my Medicare. If I've got a true, and this is where you have to reach out to, you know, maybe whoever you bought your Medicare supplement or Medicare Advantage plan to confirm how your plan works. And I recommend that you do understand how it works in this scenario. But my understanding, unless things have changed more recently, is that a Medicare supplement, a true Medicare supplement, is going to cover that additional 20%. Whereas a Medicare Advantage plan, it might cover part of the those next 80 days. It might cover some of those 80 days, and it might not cover some of those 80 days. I know there's for sure a gap in there where the Advantage, if you have an Advantage plan, you're out of pocket for that 20%. Okay. So my advice to you in this regard is to find out, right? Find out how your plan works. It is very important to understand this, and you know, if nothing else, be prepared. Be prepared so that if and when this does happen, you're not shocked. Or maybe you say, you know what, maybe I should adjust the plan I have. Maybe a supplement is right for me, or maybe a Medicare Advantage plan is better for me. You know, in some cases, I think people are very educated, and they spend a lot of time when they're picking through these plans. And I think in some cases they're not. People just might be saying, oh, I'm going to go with the Medicare Advantage plan because those tend to be less expensive. Whereas, maybe that supplement is going to be a little bit more costly, but we understand that the benefits that we might get out of it are going to be a lot more significant than the Advantage plan. So again, when it comes to anything, right, I don't care what you're doing, whether you're doing estate planning, whether you're buying insurance, whether you're buying a car or a house, right? Get educated. Make sure you have all the proper information you need before you're making a decision. And I understand in some cases we have to be very cost conscious. I am 100% understanding of that. Money does not grow on trees. I'm still waiting for it to do so, but at this point it still isn't. And so I get that we have to be conscious, but just at least make sure you understand what you have. I mention all this because I can tell you right now that I've had clients over the years where we get a call from a client and they've been in rehab for 30 days, and all of a sudden they get a bill and the bill's $20,000, and they're like, "Man, what the heck's going on here?" Right? We thought that Medicare was going to cover the rehab stay, and they go back and they realize they did not have 3 nights inpatient status in the hospital prior to discharge. Now, a lot of people think if I'm sleeping over in the hospital, I'm inpatient. Of course, I'm inpatient status. Now, here's the reality. I'm not a doctor. I'm not a nurse. I'm not a medical professional. I don't know all the ins and outs of that. All I can tell you is that sleeping over in a hospital does not equal being considered inpatient. You can definitely be under observation. You could be in the hospital for 4 nights, and every night could be observation. So I highly recommend that if you are in the hospital for an extended period of time, and when I say extended period, a couple days, or if you have a loved one in the hospital for a couple days, you are asking on a daily basis and making sure you know how they are being categorized. Am I inpatient? Am I under observation? And if they're saying that you're under observation, maybe you ask why. And if you feel like you should be inpatient, there are, and it just might sound extreme, but there are patient advocates out there that you can reach out to that can help in these situations and maybe speak to the doctors or the nurses and maybe question why you're being considered under observation when maybe you should be inpatient status. The reality is that, let's just look at the big picture, and I don't mean to go off on a tangent. We'll get to the asset protection that you all came here for. But hospitals are paid the majority. Their biggest payer is Medicare. And I'm sure that doesn't come as a shock to you, right? So if the biggest payer to the hospital is Medicare, the hospital sort of has an incentive to not force Medicare to pay more money for their patients when they discharge them from the hospital. And so if they can maybe mark somebody as under observation versus inpatient status, knowing that the rehab will not be covered by Medicare, Medicare is going to like that hospital more. Somebody explained this to me years ago, a medical professional. Believe me, I didn't come up with this on my own. But when you think about it, it makes sense. Okay. And it shouldn't be that way. But again, let's just not be naive to think that a hospital, even though they're there to take care of us, at the end of the day, isn't there to make money. Okay. And so it's just something to keep our eyes open to. That's all it is. And this is not a shot against medical professionals at all. I mean, they are taking care of us. They're doing everything they need. It's more of an administrative issue, okay, unfortunately. So just be conscious of that, please, and ask questions. Don't be afraid to ask those questions. You got to make sure that you're being taken care of and you're taking care of your loved ones. All right, that aside, all right, so now we know what Medicare covers and what Medicare doesn't cover for the most part in the realm of long-term care. So now let's talk about the idea of Medicaid. And there's different forms of Medicaid out there. The 2 main forms of Medicaid, okay, are Medicaid more as like a health insurance tool, right? For those that are not living in any kind of long-term care facility, but they're accessing Medicaid as their version of healthcare or health insurance, right? And they're typically, this is going to be for somebody that's living under the poverty level from an income standpoint. And I'm not going to sit here and give you all those numbers. That's not the type of Medicaid we're talking about. And that's not the type of Medicaid that we assist folks with in our office. The type of Medicaid that we're going to discuss today is strictly related to long-term care. All right. So we'll call it long-term care Medicaid, if you will. So when we have long-term care Medicaid, we'll look at it. I'll talk about it first in the sort of related to a single individual, and then we'll talk about how it works with a married couple. And there were some changes with long-term care Medicaid in as recent as last year in 2023. And I've been doing this since 2011. I've been in this area of the law, so almost 13 years now, and it's the first time there was a change in some of the financial figures related to Medicaid in 13 years. So if I'm a single person, well, let me back up one quick second. If I'm applying for Medicaid in a long-term care facility, there are two types of facilities that will take Medicaid in Illinois. There are the facilities that most of us are aware of, which are nursing homes, skilled nursing facilities, we call them. You might hear somebody in the professional setting call it a SNF, skilled nursing facility, SNF. Now, not every single nursing home takes Medicaid. Some do and some don't. I would argue that the majority of skilled nursing facilities that are within a 5-mile radius of the YMCA, majority of them do take Medicaid. Okay. It's more common for us to see nursing homes that take Medicaid around here. The facilities that you're going to see that for sure don't take Medicaid are going to be anything assisted living. So anything under the assisted living umbrella is 100% private pay. All right. And they don't care how you pay for it, whether you're using your income, your assets, long-term care insurance, your kids want to help you pay for it, etc. But assisted living is going to be private pay only, no Medicaid. Similarly, we have memory care facilities, right? And these are popping up more and more. For the most part, I'm going to say 95%. If it's a memory care facility, it's private pay. Every once in a while, you're going to run into a skilled nursing memory care. Okay, so a combination of the two. And even in those cases, majority of the time, it's going to be private pay. There are a very few out there that I've ever heard of that say they are memory care and also take Medicaid. It's just typically not what you see. And the reality is that you need a more trained staff to be dealing with Medicare, and for that reason, typically it's harder to have Medicaid be a part of the model because there's less money than going into that facility to pay the staff. Okay, so just something to consider, right? So the two types of places are skilled nursing facilities, right? And not all of them take Medicaid, some of them do. So you want to make sure that if you're looking at one for a loved one where you believe they will run out of money at some point, you definitely need to make sure they take Medicaid. And then the other type of facility in Illinois that takes Medicaid is a supportive living facility. Okay. And somebody might refer to that as a SLF, SLF, right? Supportive living facility. Supportive living facilities are not as common, I'm going to say, like on the North Shore. We see some in, that they tend to be, and somebody on here can put something in the chat and correct me, but we tend to see them more either in the city or a little bit further, like Lake County, McHenry County are the ones that I'm more familiar with. I'm sure there are some in other counties, but you don't see a ton on sort of like the North Shore, Greater North Shore. Okay. And a supportive living facility from a care standpoint is going to be a little bit more similar to like assisted living. All right. So it's going to be the type of place where, I need some help. I need help with some activities of daily living, but I can still, do some things on my own. Whereas a skilled nursing facility tends to be more of that top level of care, more significant level of care, where I'm not able to do as much with regarding my activities of daily living, and I need a lot more assistance. Okay, so again, those are the two types of places where we can apply for Medicaid, and whereas with skilled nursing facilities, I said some take Medicaid, some don't. Any facility that's under the umbrella of supportive living takes Medicaid. Every single one. It's not like there are some supportive living facilities that do and some that don't. Every supportive living facility accepts Medicaid. Okay, so something to be aware of. Also, a lot of the supportive living facilities, I'll say, or a number of them, tend to have waiting lists, right? Because unfortunately, there's a large part of our population that cannot afford to pay for long-term care. They need to go into a facility of some sort. They need to apply for Medicaid, But you've got a lot of people that end up in nursing homes strictly because they can't afford it, and that's where they can access Medicaid. Whereas really they probably would be more appropriate for a supportive living facility, but the supportive living facilities tend to get pretty crowded and pretty full. And again, those tend to have waiting lists. So I don't think Illinois has changed it. I know I think there was a moratorium, and it's been going on for a while where they're not allowing any more supportive living facilities to open up. Again, maybe my facts are old, maybe that's changed more recently and I'm just not aware. But we as practitioners in this area hope that it does increase and that other ones are able to be built, because there is a strong need where we've got younger individuals that need care, but they don't need the type of care in a skilled nursing facility, and they would definitely be more appropriate for supportive. So there's a question: is the coverage in supportive living facility national as well, or only in Illinois? I'm actually not sure. Unfortunately, I am only aware. We only practice in Illinois, and we don't. To be honest with you, we don't really keep up on what's going on in other states. Just as it's not really relevant to our practice. So I can't answer that. I'm sorry. I'd probably recommend reaching out to either an elder law attorney or maybe a care manager or social worker that works with older individuals in a particular state, if you're looking at a particular state. All right. So if I'm applying for Medicaid, and I'm going to really talk about a skilled nursing facility versus supportive living. Okay, that everything works out pretty similar. I will mention one very slight difference, but for the most part, figure I'm talking about Medicaid and nursing home. But again, it's virtually identical how the two work out. So if I'm a single person applying for Medicaid in a skilled nursing facility, I am allowed to have $17,500 in my name. Now, for anybody that is aware of how Medicaid worked a year ago, even, that was not the case. So before, I could have no more than $2,000 in my name, right? So this just went up from $2,000 to $17,500. So a pretty significant change, right? So as a single person, I can have $17,500. Okay. And that's all assets, just so we're aware. All right. So that's, a total of what I can have in my checking accounts, savings accounts, money markets, brokerage, cash value of life insurance policies. I mean, everything has to be at or below 17,500. Okay. When you total all of it. For most individuals that are applying for Medicaid, at least if we're involved, we're probably recommending, okay, we're going to get rid of all the accounts you have for the most part, and we're going to just put everything in one account. We want to keep it simple. A lot easier to keep track of not going over a certain number if it's in one account versus 3 or 4 different accounts. And then if I'm moving into a skilled nursing facility, I get to keep $30 a month of my income. If I'm going into supportive living, this is really one of the only differences. If I'm going into supportive living, I get to keep $90 a month of my income. All right. Back to skilled nursing. So I get to have $17,500 in the bank, and I get to keep $30 a month of my income. That means that, if I've got $3,000 coming in from Social Security, and, whether it's $3,000 from Social Security or $2,000 from Social Security plus $1,000 pension, if I've got $3,000 a month of regular fixed income, we will always recommend to our clients that they keep their Medicare supplement or Medicare Advantage plan, because you can still pay for that, right? So I can pay for my Medicare supplement, I can keep my $30, and then the remainder of that is going to go to the nursing home. Okay. But, the nursing home's bill is $10,000 a month. I'm paying them maybe $2,500. Medicaid's picking up the rest of the tab, right, at a reduced rate. Right? So in most of these cases with a single individual, especially, we would recommend that somebody keep their Medicare supplement or their Medicare Advantage plan, because that way, if God forbid they have to they have a medical event and they have to go to the hospital, or there are certain doctors that they see, they can still see those doctors because those doctors might be more likely to take the supplement as a secondary payer source versus Medicaid. Because if they drop their supplement and now Medicaid becomes their secondary payer source, they may not be that might have certain doctors that would not see them. Okay. So a question here to clarify, is an IRA is considered an asset yet? Is an IRA, well, I'll just say IRAs are assets. So when I say that I'm as a single person, I can have $17,500, that's everything. Okay, that's checking, savings, money market, an IRA, a 401k, an inherited IRA. Everything. Illinois considers IRAs as part of that asset equation. You know, I don't really know I don't follow Medicaid in any other state, and unless it's changed recently, then I'm wrong, and I apologize for giving you this, but it probably doesn't matter for most people. I always knew that New York, unless they've changed their rules, I believe New York, the IRA is not considered an asset for somebody going into a nursing home, and it's excluded, which is significant, clearly. But in Illinois, anything. I mean, like I said, checking, savings, money market, IRAs, 401ks, cash value of a life insurance, of a whole life insurance policy. There's not much that Medicaid is not considered to be an asset for an individual. Okay. And I also want to be clear that if I have a house, if I'm a single individual and I have a house, I will need to sell my house. I am not able to keep my house. Okay, and this is important to understand as well. We have people that we meet with all the time that, I mean, they want to maybe pass their house on to their son or their daughter or whoever it is. And I'll talk about this for a quick second here, because there are a few exceptions. I'm not going to go into all of them, but I will talk about two exceptions that we've seen come up over the years that tend to be the more common exceptions. Okay. But let me wait for that, because there's one more part of Medicaid that we haven't discussed. Medicaid also has a 5-year look back. All right. That means that when I go to apply for Medicaid, the state will want to see 5 years of my financial information. What does that mean? That means I need to turn over 60 months worth of bank statements or statements for every checking account, savings account, money market account, IRA, 401k, anything regarding a life insurance policy. They need to know if I have owned any real estate in the last 5 years. Okay, we need to give them all of that. And what Medicaid, what the state is looking for is, did I give anything away? Did I make any, the phrase that we would use is, were there any transfers for less than fair market value? Okay, because there's a difference between me just giving something to Pam versus there being a transfer for less than fair market value. Right? So we would all agree, I would think, and everybody's on mute, and I appreciate that. So I'll just pretend that you're agreeing with me. But we probably all agree that if I wrote Pam a check for $10,000, that would be a gift. Right? Yeah, she'd love it, and it would be a gift. However, if I sold Pam my car that was worth $10,000 for $1,000, we would not consider that to be a gift. We would just consider that to be a really good deal for Pam. And so here's how the state looks at all that. So if I write a check to my kids for $10,000 sometime over the last 5 years before I apply for Medicaid, they're going to penalize me for that. But it's going to be no different than if I sell my car that's worth $10,000 to my son for $1,000. Now, it's not a full gift, but what they're going to say is, Matt, it was worth $10,000. You sold it for $1,000. You basically, you made a $9,000 transfer for less than fair market value. Right? Or I always love my clients where they're like, well, what if my dad sells me his house that's worth $200,000 for $10,000? I'm like, he can do that. But Medicaid will say that he basically gave away $190,000. Okay. And so if there are any transfers for less than fair market value that occur in the 5 years prior to applying for Medicaid, and it does not matter if it was 4 years and 8 months ago or the month prior to applying. Okay, they don't prorate the gift based on when you gave it away. So if there was a gift within that 5 years, they're going to give me a penalty. And let's talk briefly about how that penalty works. Let's just say I'm moving into a nursing home and the cost of care is $10,000 a month to make it really easy. And that's a pretty good average for this area anyway. The cost of care is $10,000 a month. And let's just say that I'm applying for Medicaid. I'm down to $17,500 in assets or less. I don't have any real estate, but when the state is looking through all of my bank statements, et cetera, they see that I gave away $30,000 over the last 5 years. Okay. However, I gave it away. And I can't argue. All right. I agree. I gave it away. Now, whether I did it for purposes of applying for Medicaid or not really doesn't matter. So even though the Medicaid policy strictly states if you made a transfer for less than fair market value in anticipation of applying for Medicaid, it's a no-no. The reality is their default will always be that you gave it away with the anticipation of applying for Medicaid. And that was the case even with a client of ours who had a sudden immediate stroke at a young age and applied for Medicaid. And there was no way that the money he gave away to his daughter a couple of years prior could have been construed as giving it away for Medicaid reasons. Didn't matter. Okay. So let's say I gave away $30,000. Otherwise, I'm eligible to apply for Medicaid. So what's going to happen is the state's going to approve my application. You're going to say, Matt, you're approved, right? Let's say I'm approved for Medicaid and it's, February 1st. But here's what's going to happen. Medicaid, the state's going to say, you're approved, but you need to figure out a way to pay for February, March, and April. You need to pay for the next 3 months out of pocket. And here's why. The state is going to take the amount of money that I gifted and divide it by the monthly cost of care at the nursing home. And that's how many months they're going to make me wait until Medicaid pays, right? Because in their eyes, had I not gifted that money, I wouldn't have had to apply for Medicaid for another 3 months.
12. Oh,
okay.
12 o'clock or something.
So something to consider. The only difference with a supportive living facility, this is the last kind of difference I'll make, is with a supportive living facility, rather than taking the monthly cost of care and using it as the divisor, if you will, to come up with the penalty. So if I was in a supportive living facility, and let's just say that it cost $6,000 a month, they wouldn't do 30,000 divided by 6 to figure out the penalty. For supportive living, it's a fixed number, and I can't remember it exactly. It's a per day amount, so it comes to about somewhere between $5,000 and $6,000 a month. Okay, without giving you an exact number, and that's what they would use as the divisor to figure out the penalty. But for a skilled nursing home, they take the exact monthly cost of the nursing home, and they use that. They take the amount that you gifted, they divide it by that, and that's your penalty. Not an ideal situation to be in. So people that are just, thinking that they're going to skirt the system and start gifting assets to their kids or their grandkids or et cetera, not a good idea. Do not recommend it. Okay. There are ways that we can protect assets. That is not the right way to do it. What are a couple exceptions? Back to where I was at before. One is if I have a caregiver child, not a grandchild, not a niece, not a nephew. If I'm a single individual applying for Medicaid, moving into a nursing home, and I have a house, and I have a child that has been living in my home with me and taking care of me for at least 2 years leading up to applying for Medicaid. And there's some other things. I mean, we've got to show proof that they were living with me and proof that I actually needed care, not that they were just an adult child living in my home, right? So it's going to require getting a doctor's letter saying that I actually needed care for the last 2 years or 4 years or 6 years, however long my child was actually taking care of me. But if I've got an adult child that's been living with me and taking care of me for at least 2 years before I leave the house and apply for Medicaid in a facility, I can transfer my house to that adult child, and it's not a gift. Okay. We call it the child caregiver exemption. Okay, so that's one that we see here and there. Again, few and far between, but it comes up. The other one that we see even less than this, but it's come up once or twice, is that if I have a child who is receiving SSDI, Social Security Disability, If a child is receiving SSDI, I can gift them an unlimited amount of assets before applying for Medicaid, and that gift does not impact me. There's no penalty for that. Okay, so those are the two that we see that I think are worth mentioning. Otherwise, there might be some other ones out there, but they're ones that really don't really come up, and I can't even really think of off the top of my head. The last one would be you can create and gift money to a special needs trust as well. So if you have a child or grandchild with special needs, you can create a special needs trust, put money in there for them, and that would not be considered a gift either. All right, so sorry, there's 3. Now let's look at a married couple. Okay. And the last thing with that single individual, sorry, is that if I've got a house and I can't give it to my child caregiver because I don't have one, I have to sell the house. Okay, I have to sell the house. I get the proceeds. Now I spend down the money at the nursing home. And then after I spend all that money, I get on Medicaid. Or I apply for Medicaid. And I'm in the process, I'm selling the house. And then once the house sells, I get the proceeds. And I'm temporarily removed from Medicaid until I spend all that money down. And then I get back on Medicaid. There's a question in the chat box, but I'm gonna wait until the end to answer that. Any more questions in the chat box, guys? I'm just gonna let you know. I'm gonna answer at the end. I wanna make sure I get through everything. But that's a good question that you had there. So for a married couple, if I'm going in the nursing home and I've got a spouse living at home, I can still only have $17,500 in my name. But my spouse can have $120,780. $120,780. This number also went up last year. This used to be $109,560, I want to say. Okay, so this went up about $10,000, $1,200 or so. Or sorry, $10,200. So my spouse can have $120,780 plus a house plus a car. Okay. So my spouse can still keep living in the house. There's no limit on what the house can be worth. I've had clients ask me this over the years. I don't care if it's a $200,000 house or $1 million house. Medicaid at this point does not care. The spouse gets the house. All right. From an income standpoint, I still only get to keep $30 a month of my income, right, for a skilled nursing facility. My spouse, my wife, can have $3,715 a month. That number also went up last year. That went up about $1,000. It used to be $2,769 or $2,739. I'm already forgetting at this point. But that went up about $1,000. Okay, which again is significant, right? Here's how this works. All right. Let's just say that my income is $2,500 a month, and my spouse's income is $1,000. If I was single, I could pay for my Medicare supplement, keep $30, and otherwise the remainder of my income would go to the nursing home. But in this case, I'm not single, I'm married, and my wife's income is $1,000. So what I can do is I can keep my $30, I can pay my Medicare supplement. Let's just say now that takes me down to $2,200. I can transfer my income that would have otherwise gone to the nursing home if I was single. I can transfer my income to my spouse to get her up to $3,715. So if her income is $1,000 in this example, I can give her all $2,200. So basically, in this situation, my wife and I would have to give no money on a monthly basis to the nursing home. I'd still be on Medicaid. Medicaid would still pick up my tab, but my wife would get to keep all of our household income. Now, of course, this is different if we had much higher incomes, or if my wife, her income already was over $3,715, then I'd be able to transfer it to her. But in more cases than not, especially with this increase, even when it was $2,700, in a lot of cases with a married couple, we could keep most of the income with the spouse. But especially now that it's gone up to $3,715, it's so common that the spouse can keep most of the income. Okay, so this was a nice change. And then the 5-year look back period still applies with a married couple. And actually, they're going to look at not just accounts that are in my name or joint accounts, but they're also going to look at accounts that are in my spouse's name as well. So even if my spouse has her own checking account, own investment account, own IRA or 401k, they're still going to want to see 60 months of bank statements for her and for those accounts. And any money that she might have gifted from an account that was her name only will impact me. Okay, we're looked at as a family unit when we're applying for Medicaid, even though it's just Medicaid for me. How do we protect assets? So there's really two ways that we can protect assets for the most part. And I'm going to be brief here. I'm not going to go into tons of detail. For sake of today, I don't think we don't need to get into the nitty gritty. But there's sort of two types of asset protection planning we do. One is more from a pre-planning standpoint, I'd say being more proactive. The other one is more of a crisis plan or a little bit more reactive. Not that it's a bad thing, honestly, but that's sort of how we refer to it. So from a pre-planning standpoint to protect assets, really what we're looking to do is plan at least 5 years in advance of when we think we might ever need Medicaid. And obviously that's hard, right? I always joke around with clients. I'm like, we don't have a crystal ball. We don't know if and when we're ever going to need long-term care. But we meet with clients, and typically it's not clients that are any younger than like mid to late 60s, almost at the youngest for the most part, is when people maybe start to have this idea of, hey, listen, we're not multimillionaires. We've got a couple $100,000 in a house, but we're concerned that if one of us needs long-term care, we don't want to impoverish our spouse. Or, not only that, but we want to make sure that there's something left for our kids or our grandkids or whatever it is. But most of the time, the main concern is the spouse, right? I mean, if something happens to one of us, we don't want to spend all the money in the nursing home and then leave our spouse, who might be very healthy, who might be 10 years younger, with not a lot. So if we have more than 5 years on our side, or we think we do, typically what we're going to do is we're going to create an asset protection trust. So we call it a Medicaid asset protection trust in our office. Different attorneys call it different things. It's a form of an irrevocable trust. Okay. I'm not going to get into all the details necessarily, but there are two main types of trusts out there: revocable and irrevocable. The revocable trust is the type of trust that majority of people who put a trust in place when they go to do their estate planning with a lawyer. The revocable trust is the most common type of trust, right? This type of trust, I put my bank accounts in it, I put my house in it. I'm the trustee, meaning I get to control everything. I can still do whatever I want with my money, write checks, sell my house, blah, blah, blah. And the trust is for my benefit during my lifetime, or my wife and I during our lifetime. And when we die, everything goes to our kids, right? That's like how a revocable trust works in a nutshell. And the goal of most revocable trusts are to avoid probate, to make sure that our estate doesn't go through the court system when we die. And there's a simple administration. But a revocable trust provides no protection from Medicaid, no asset protection. Probate protection, yes, but not asset protection. So if we want asset protection, and again, people are typically coming to us more for Medicaid reasons. People aren't coming to us because they are in some kind of risky business and they're trying to protect their assets. So what we do is we look at an irrevocable trust. And the irrevocable trust, to be really simple about it, let's say my wife and I are creating it. We are looking to protect our assets. We can create the trust and we can put assets in there that we want to protect. But the trustee, as far as who can manage the trust, cannot be us. So 99 out of 100 times, our clients are going to name an adult daughter or an adult son, or the two of them together as trustee or co-trustees. Similarly, the trust cannot look like it's for our benefit during our lifetime. So the way the trust is set up is not only does the money go to our kids when we pass away, but during our lifetime, the trust is set up to look like it's for their benefit. It's like gifting our kids the money without putting it in their names directly. Okay. But this is a gift. We're putting our money into a trust that's not for our benefit. And so if we did this 2 weeks before applying for Medicaid, we'd get a penalty. It'd be no different from a Medicaid standpoint than if we did, in fact, just give it to our kids. And so if we're doing this, ideally, we're doing this more than 5 years before we are applying for Medicaid. And there's a difference between doing it 5 years before we apply for Medicaid and 5 years before we need care, because some clients come to us and maybe they're already starting to decline from a healthcare standpoint. But they think that they wouldn't probably need to apply for Medicaid for 5 years because of the assets that they have, or maybe they've got really good income and their income is enough to help support maybe paying a caregiver here and there. Or they have a long-term care plan that might kick in and be able to pay for, the next 3 to 5 years, but then it's going to run out and then they're going to have an issue with paying for care. Again, there's different reasons why we might do some proactive planning. To be really quick on this, the way this trust works, because I always tell clients are always like, well, what if we need money? What if we put money in that trust and we actually need to access it at some point? Well, the way it works is that my son, let's just say my daughter's the trustee, and my son and my daughter are the lifetime beneficiaries. If we need money at some point, we tell our kids, and my daughter's the trustee. She writes a check from the trust to herself, or from the trust to her brother, our son. That person deposits the money in their bank account, and then they turn around and they gift it to my wife and I, right? Mom and Dad, I love you so much. Here's $10,000 of your own money, right? And when we're doing this, there's no gift, there's no gift tax or anything like that that our kids need to deal with. But when they turn around and give us the money, we've got to be conscious of how much they're giving us, and could there be any, reporting consequences to the IRS? I won't go into all of that, but typically there's not. You can gift a certain amount of money to people per year without having to report it and without it coming off of your lifetime exemption. So for the most part, for today, we won't be worried about that. Basically, there are ways to still have access to the money. But we always tell my clients, you cannot have money go directly from that trust back to my wife and I. It cannot go directly from the trust to us. It has to go to one of the lifetime beneficiaries, and then they can personally give it to us. Because if the trust gives it to us directly, guess what? When we go to apply for Medicaid and they look at 5 years of our bank statements, they're going to see that money was transferred from some random trust account to us. And then they're going to ask about it. And then we're going to show them the trust, but we're going to say that trust protects our assets. And they're going to say, too bad. That trust gave you guys money directly. So even if that was a mistake, you just tainted the trust. And they're going to argue that all that money is available. And we've had clients do that. We've had clients where we told them 10,000 times, don't do it this way. And or before you start taking money from the trust, reach out to us so we can remind you the right way to do it. And inevitably, we've had one or two over the years that not listen to us. And they put themselves in a pretty bad situation. That's how we protect assets proactively. Okay. And I always tell clients, I'm like, I look at that type of trust as like an insurance policy. Maybe you never need Medicaid. Hopefully you never need Medicaid. And we put together this trust and we put that money in there just in case, but we never need to reap the benefits of it. Great. It's like paying for health insurance or auto insurance or homeowners insurance and never having your house burned down, or never getting in a car accident, or never having a serious injury and going to the hospital. We still pay for all those insurances every year. And we're not mad if we don't really reap the benefits of them. And I look at that type of trust when we do it proactively very similarly. If it helps us, great. If it never does, pennies on the dollar for what it protected. Okay, regardless as to who you work with. In a crisis plan, so we are aware that most people don't plan proactively, right? Nothing wrong with it, just the reality. And so a lot of people come to us when they're on the doorsteps of needing Medicaid, right? A wife comes to us, my husband's in the nursing home, he's in rehab, Medicare's covering it right now, but you know what? The rehab facility just told us that in 5 days, Medicare is going to stop paying for him. And I didn't mention this prior when I was talking about the 100 days that Medicare might cover, but Medicare covers up to 100 days. You could be on day 37, and if the rehab facility determines that you're not making any progress and you really can't do much more, or you're not trying and you've plateaued, then they will typically give the family notice and say, you know what, in 4 days or 5 days or in a week, Medicare is going to stop covering Matt. He can stay here long term, but it's $350 a day. And so we have a lot of people that come to us where that's the case, right? We just found out Medicare is going to stop covering it. My husband's day, it's $350 a day. How do we protect some of what we have? I'm concerned, right? We've got $400,000 in a house, and I don't want to have to spend $280,000 until I'm down to $120, and then we can apply for Medicaid for him. And so in these cases, what we can do is we can create the trust. And again, without going into tons of detail, we can create the trust and we can protect about half the assets at this last minute by using the trust and some other tools. Okay, it's a little more complicated. It's definitely nothing I can do justice to in the 5 or 6 minutes we have here, but we can protect about half the assets sort of at the last minute. So it's not that there's no options. And I really want people to be aware of that, because I think a lot of people have this idea that there's nothing we can do, right? We didn't plan the way we should have. It's too late. My husband's in the nursing home. We are, out of luck. Not necessarily. Now, again, sometimes this also depends on, when we protect assets at this, in more of like in this crisis scenario. And sometimes it's when there's a spouse still living in the house. Sometimes it might be an adult son or adult daughter for a single parent where they're trying to protect some of the assets. In some of these cases, I will say the ability to do some of this planning might rest on the type of power of attorney that the individual has. Because if we're dealing with somebody that doesn't have capacity, whether it's for a single individual going on Medicaid that no longer has capacity, or maybe the individual is going to the nursing home, lacks capacity, and their spouse is at home and starting to show some signs of incapacity. Then what we are relying on in these cases is we can still potentially do this planning, but we would have to do it through their agent named under a power of attorney for property, the financial power of attorney. And the last thing I'll say here before I take a couple questions, I'm going to leave a few minutes for questions, is that your standard property power of attorney that you might print online, that you might have gotten from your really great estate planning lawyer, that's not an elder law attorney though, your standard power of attorney for property doesn't have the right language in it that would allow the agent to do this sort of asset protection planning for their spouse or for their parent. Okay, we've seen tons of powers of attorney, believe me, over the years. And your standard form will not have the right language that we need it to have to be able to do this asset protection planning. And so it's one of those things where I tell clients, I'm like, I'm not saying you need to update your property power of attorney, but it's a good idea to look at it and see what kind of powers it has. Does it allow for any gifting of assets? Does it allow for the creation of any, irrevocable trust or Medicaid type trust? If there's any kind of language like that, you've got to be really make sure that that if you think this could be something that could happen down the road, we'll have clients that come in where we update their power of attorney for property just in case, just because it gives them a little bit more power and the ability to do some of this planning later on. And don't be confused by the language that's in every single power of attorney that allows the agent to create a revocable trust on behalf of the principal, right? So my agent, if I'm named as power of attorney for my dad, I'm considered the agent for him. He's the principal, I'm the agent. So every power of attorney out there is going to have language that says I can create a revocable trust for my dad. Okay, but it's not going to say that I can create an irrevocable trust or that I can do any kind of like Medicaid planning or gifting of assets above and beyond what the IRS might allow. So again, just I'm providing this for a little education. Take a look. Again, this may not apply to everybody. I'm not saying you need to go run out and update your powers of attorney for property. Just something to be conscious about, because we've had clients come to us where they were interested in protecting assets, but the individual is incapacitated and we could not do the planning strictly because of the language in the power of attorney. So I've told clients, I'm like, the ability to protect $50,000 or a couple $100,000 of assets has rested on the language in a power of attorney. That's pretty powerful. So just something to consider. But it is 10:13, and I've got, depending on Pam's schedule, I can definitely answer a couple questions if you have them. But there's one in the chat box, which I will get to. And then if anybody else has any, or Pam, if anybody's giving you any, you can let me know. But one here was, will Medicaid pay for skilled nursing care for an individual if the individual resides at home of a relative, okay. So I'm assuming, Lee, and this question was asked, I think, to everybody. What you mean is basically, can somebody will Medicaid pay for care in the home? The skilled nursing care would be in a skilled nursing facility, but I think the question is I think the way I'm interpreting it is, will Medicaid pay for any services in the home? And the answer is yes, there is a slight Medicaid benefit out there. It's actually through the Department of Aging, and it's a Medicaid waiver program called CCP, Community Care Program. We don't deal with this. We don't apply for this for folks. It's a pretty easy benefit to apply for. We don't feel that people need our help to apply for it. Medicaid's another story. Medicaid's can be a monster for people, and so we feel like we can help people in that regard. But CCP, so if you look it up, you can look it up online. Community Care Program. It's through the Department of Aging, and typically how it works is there's a certain asset. You can only have a certain amount of assets in your name. I'm not sure if your income has to be at or below a certain limit. And then my understanding is how it works is if you meet those income and asset requirements, they send somebody out to meet the person. They kind of figure out what their needs are, and they give them what they call a DON score, a determination of need score. And based on that, they might say, all right, you qualify for 15 hours of help a week that the state will pay for, or you qualify for 30 hours a week that the state will pay for. So it's a limited amount. I can tell you, for somebody that needs pretty consistent care, it's not going to be enough. It definitely won't. I've never seen anybody get more than 35 hours a week. And if you're talking somebody that needs full-time care, that's not enough. But that program does exist. So there is a slight benefit that Medicaid provides in the home.
All right, any other questions from the group? Thanks, Matt.
Yep.
All right, so maybe you covered things. If you do have any questions, you're free to contact Matt, and he will answer your questions. And then also, I know he does will have, if you're interested in having a session with him, he will do that as well. Yay. All right, well, thank you. Matt's next talk is next month on March 6th. He's going to talk about estate planning. So if you have any other questions for him about estate planning, he'll have a whole nother session there. Yes, today's topic has been recorded. It'll get posted to our website in a few hours, so it should be there by the end of the day today. Our next talk is on the 15th, next Thursday at noon. We're going to talk about how to heal your heel pain. So you can talk with Denise, who's a physical therapist, to talk about how you can heal your heel pain. Otherwise, we'll see Matt next month on March 6th for estate planning. Thank you all very much for being on the call today. And I love hearing from you, Matt. Thank you so much for helping us know what our future, have a better idea of what our future is. So thank you so much.
You got it.
Bye, everyone.
Bye, guys. Thanks, Pam.
Bye. Yay. Thanks, everyone.